Thank you everyone for joining us. This is the National Women's Law Center's Legal Network for Gender Equity webinar on using Title IX to end gender disparities in athletics. As you can tell, we have recorded the session. We'll be making this recording available on our website as well as the slides on our website. So you can look forward to that. You can turn on captions if you want assistance. We have a captioner with us today. Thank you so much to Christine Joseph for being here and making our webinar more accessible. And as you all know, and thank you to Jennifer in the chat for letting folks know the same thing about the closed captioning. As you all know, you can put your questions in the chat at any time, or you can use the Q&A box to make sure that our panelists can answer your questions either during the webinar or they can type in their answers directly in the Q&A box. And if you have any questions about the Legal Network for Gender Equity, if you're currently not part of the network but would like to join, you can let us know by emailing me at any time, emailing legalnetwork@nwlc.org, or replying to any email that you received from us about this webinar today. It will find its way to us and we'll make sure you get the information that you need to join the network. Can we go to the next slide, please? Great, so I'm so pleased to have with us today some really brilliant, amazing experts on athletics. We have Sarah Axelson, pronounced she, her. Sarah is Vice President of Advocacy at the Women's Sports Foundation. We have Arthur H. Bryant, pronounced he, him. He is an attorney at Bailey Glasser. And then we have Kim Turner, pronounced she, her, Director of Gender Equity Initiatives at Coaching Corps. And then I'm Elizabeth Tang, pronounced she, her, and I'm Senior Counsel at the National Women's Law Center. We're excited to be here today. Next slide, please. So as I said, the Legal Network for Gender Equity is a network that the National Women's Law Center hosts, and we connect people who have experienced sex discrimination as a student, as a worker, or as a healthcare patient with attorneys like you. So if you are interested in joining, let us know. For any technical assistance, you can contact that email address on the slide, as well as in the chat, legalnetwork@nwlc.org. Next slide, please. All right, well, we're going to get started. I'm going to turn it over to Sarah Axelson to talk about gender disparities in school athletics.
Thanks so much, Elizabeth, and thank you everyone for joining us today. You can go ahead to the next slide. As Elizabeth mentioned, I'm Sarah Axelson, Vice President of Advocacy with the Women's Sports Foundation. Next slide, please. So today we're here to talk about Title IX. This is the statute in 37 simple words. This is Title IX, and you'll notice that it talks about prohibiting discrimination on the basis of sex in federally funded educational institutions. It doesn't talk about sports specifically in the rules, in the language of the statute, and that's because Title IX applies to every aspect of a federally funded educational program. But today we're here to discuss its application to athletics. Next slide, please. Elizabeth is going to go in much more detail on the intricacies and the legal interpretation of many aspects of the law. But I want to just give a real brief overview before I get into how some of this manifests in schools. So Title IX and athletics requires compliance with three main parts: participation, and schools can comply with the participation requirement of Title IX using the three-part test, and Elizabeth is going to go into that in much more detail later. The second portion is athletic scholarships, and the third is benefits and services. So schools have to comply with all three aspects of this. I'm going to go through and just give some interesting stats and facts and some of the things that we see as some of these gender disparities play out across the country. Next slide, please. So this is a graph showing the high school participation totals for participation opportunities in high school sports. You'll see that lower line is girls' participation and the top line is boys' participation. And opportunities have grown exponentially. They've grown over time, but what has remained consistent and persistent is this gap that we see. And while the gap may have narrowed since the passage of Title IX, it's still very clearly apparent. And so one not so great fact is if you look at where the graph is for present day, and you follow all the way back to 1971, you'll notice that girls today still don't have the same level of participation opportunities that were afforded to boys in 1971. So while we've made great progress, we still have so much more work to do. And on the next slide, we'll see the same stats mirrored for college participation as well. You can go ahead to the next slide now. Thank you. So for college participation, it's very similar, where we see that the gap has narrowed since 71, but really not by much, and that women are still not on par with men in the offerings that they see, and the gap has remained pretty consistent over the last few decades. Next slide, please. So oftentimes we hear this myth that Title IX takes away opportunities from men. But as you see here, there's, the blame is put on Title IX as men's opportunities are taken away, while certain sports are provided ample budgets. And so one thing, if we'll go to the next slide, one thing that's really helpful to look at and to talk about that helps rebut that argument is to look at the teams added and dropped over time. And you'll see here that over time, almost every level is net positive in terms of more sports are added than dropped, right? We expect that sport popularity is going to change over the decades, right? One sport might be popular today, and in a few decades, it may not be popular. A school might choose to drop that sport if they don't have the interest and add a new sport. But at the end of the day, at most levels, we see a net positive effect of teams added for both men and women. The one place where the teams dropped exceeds the teams added is in NCAA men's Division I, right? And so what is that synonymous with? And that is often where most of the money is, right? And so making sure that we understand that teams being dropped is not about Title IX's fault. It is about how a school chooses to prioritize its budget and how it chooses to invest in certain sports more so than others. Next slide, please. The second portion of Title IX that we talked about earlier is athletic scholarships. And again, Elizabeth will handle the details of this. There's very clear directive of what is compliant with Title IX scholarship portions. Next slide, please. But the question becomes, why is this important, right? Why do scholarships matter? And that's because of the billions of dollars that go into athletic scholarships every single year. And this graph shows you just how much money is allocated through athletic scholarships. And these are actual educational opportunities, right? This is back to why Title IX actually applies to athletics. And that's because in our country, athletics is part of our school system. These are educational opportunities. What we receive through our students and our kids playing sports are educational opportunities and lifelong skills. And we want to see that afforded equally to boys and girls and men and women. And same goes for athletic scholarships that are educational opportunities being afforded to student athletes. Next slide, please. And the third portion of Title IX is benefits and services. And so this is literally everything else that goes into a sport experience. Next slide. This is everything from facilities, coaching, scheduling of practice, scheduling of games. And often we refer to this as the laundry list, right? It's just everything else that goes into a sport experience, everything else that is part of the student athlete's impression of their sports experience. So a few notes on the benefits and services. There is absolutely no booster club exception. And what this means is that it doesn't matter where the money or the benefit comes from. A school is required to ensure that it is treating its student athletes equitably, regardless of what the source is. And the second note on this is just that Title IX is what I often refer to as a total program law. And so while sometimes we can compare sport by sport at a school to get a general sense of how a school is treating their student athletes, for legal purposes, you want to take a step back and you want to look the entire, boys or men's side and compare that to the entire girls and women's side and see if that experience is comparable. So sport by sport often sheds light on what the experiences are in a school, but it doesn't tell the whole story, right? Because oftentimes there are also sports that don't have equivalents on each side, and those sports still count towards that overall experience that student athletes receive. So if we'll go to the next slide, this is actually, I wanted to give some real world examples. This is a dad in South Carolina from a few years back. He actually filed a Title IX lawsuit in his town. And this is the softball field. He had a daughter playing softball. And this is him walking the reporter around, showing some of the issues with the field. Now, I grew up playing softball. This field looks pretty fantastic to me compared to some of the fields that I played on when I was younger. But when you start to look more closely at this field, what you see is in the first picture, there's water on the field because it had just rained. The netting is not attached to the backstop, so during games, balls can get through. That middle left picture, there's actually a drainage grate in the middle of the outfield, which just seems like an accident waiting to happen and a safety concern for these athletes. That middle right picture is a picture of handicap parking that is actually on an incline and on grass at this field. And that third bottom picture is the inside the roof of the dugout where you can see nails coming through. And so obviously, once you start looking at it in more detail, there are some things that could be concerning. But like I said, you want to take a step back. What does the whole school look like in terms of what they're affording to their male and female student athletes? But for the purposes of this discussion, to have that general insight into what we think might be happening, we can take a look at what does baseball have, right? And as a softball student athlete, previous student athlete, oftentimes that's where we see the most discrepancies because they're comparable. They're sports that are often offered, one for men, one for women, boys and girls, but on different facilities, right? Other sports that are offered for both usually utilize a lot of the same facilities. So the question becomes, what does the baseball field look like? And the next slide has some pictures. And when you look, they have not only a backstop, but a movable backstop for batting practice. They have a tarp on their pitching mound to make sure that it's game ready if it rains. Permanent brick dugouts that look absolutely fantastic. You can see in this bottom right picture, they have lights on the field. They have a pretty impressive press box, which I think had AC and heat and everything else. The school had just done a really good job renovating. And if I recall correctly, I think they had gotten a pretty significant donation. But the parents spoke up and said, this isn't right, this isn't equitable. And the school did end up agreeing to make renovations to the softball field as well. And if we go to the next slide, just another recent example, which I'm sure many of you have seen, right? This is out of the NCAA basketball championships. And this is from the women's basketball championship. It was a stack of yoga mats and a stack of dumbbells that didn't exceed 30 pounds. A side note is that there's some debate around Title IX's application to the NCAA as an association. We can get into details of that later during Q&A if there's time. But so for the purposes of gender equity, rather than Title IX explicitly, gender equity is a principle of the NCAA. So if we go to the next slide, which I'm sure many of you have seen, shows what the men received at their basketball championship, right? State-of-the-art weight training facilities. So this is just a really good example of some of the discrepancies that we see throughout sports. And these are some of the more egregious examples, if you will, that shed more light. If you go to the next slide, it's the gender equity task force definition of gender equity. So in 1992, the NCAA formed the gender equity task force, and the folks on that task force decided, before we can really define our work, talk about what we're doing, we need to define gender equity, right? And so the gist of their definition is essentially a program can be gender equitable when what one side has, right? What men have or what women have, that they would accept that as fair and equitable for the overall program of the other gender, right? So if you went up to male student athletes on a campus and you said, would you trade what you have for what the women have? If the answer is no, there's some concern there, right? So that's a really good just baseline litmus test of gender equity within sports. And if you go to the next slide, just one last thing that I wanted to flag is name, image, and likeness. So we are still up for debate about how this applies to Title IX. There's no federal solution yet. It's unclear if and how Title IX applies, but this is certainly something that is a hot topic, as you can see in some of the headlines that I pulled there. A lot of the current NIL deals that have been announced seem to be going predominantly to men, which is what many of us posited would happen when some of these changes were being considered. And so keeping an eye on this and making sure that if the school is involved at all, it's likely that Title IX will apply. And so making sure that as a sector that we are keeping an eye on this and making sure that NIL deals don't disproportionately impact women in a negative light. So thank you for your time, and I'll turn it back over to Elizabeth.
Thank you so much, Sarah. And now we want to talk a little bit more about the legal standards that are applied when students have a complaint against their school. And if you as an attorney are representing one of these students, what are the legal standards that you would apply to see if the school is in compliance or in violation of Title IX? Can we go to the next slide, please? School-based Title IX complaints, next slide. So as Sarah alluded to earlier, Title IX requires schools to do all of the following three things with respect to girls and boys or women and men in sports. And that is to provide equal opportunities to play, equal benefits and services, and a fair share of athletic scholarship dollars. Next slide. So let's first talk about equal opportunities to play. And in talking about this, there's actually a three-part test. So we're going to talk about three different ways to satisfy one of the three requirements of Title IX. So this three-part test, which applies only for equal opportunities to play, means that schools must comply with one of these three tests: substantial proportionality, historical and continuing expansion, or full and effective accommodation. So let's first start by talking about substantial proportionality. Next slide. Is the text there? Oh, wonderful. So this is called prong one. This prong one is met if a school can show that the number of athletics participation opportunities for girls and boys, or women and men, are substantially proportionate to each gender's enrollment. And you can calculate this in about 4 steps. So step one, you need to count the number of athletics participation opportunities, which means the number of spots on teams for girls and boys. And to get these numbers, you can use a school's web rosters. If you're looking at a K-12 team, you can go to the Civil Rights Data Collection, CRDC. If you're looking at higher ed, you can look at the Equity and Athletics Disclosure Act data, EADA data. And those links will be available to you once you get the slides. A quick note here, cheerleading is only considered athletics if its primary purpose is competition. So if its primary purpose is just to support and cheer for other teams, then it is not an athletics opportunity. And it cannot be counted to increase the number of girls' opportunities that you have in a school. Another quick note here is that you will see that the number of athletics participation opportunities at a school is going to be higher than the number of athletes at the school. And that's because if a student plays multiple sports, they are counted multiple times for the number of opportunities. So step two, you want to calculate the participation gap. And you can calculate that by taking the percentage of enrollment that is comprised for girls and subtracting from that the percentage of spots that are allocated to girls. And we'll use an example later so you can see what this looks like, but that number you get is the participation gap. The next step then is to convert that participation gap into the number of girls' spots that must be added to reach proportionality. And there's a little bit of tricky math here. You have to use some algebra. So we'll do another example on the next slide. And then finally, step 4 is you have to compare the missing number of girls' spots with the sizes of any viable teams. So a school has a viable team in a specific sport if there are enough students who want to join that team, and if there are other schools that have a sports team to compete with them. So if the number of missing girls' spots is greater than or equal to the size of a viable team in any type of sport, then the school is in violation of Title IX, and in order to close the participation gap, they have to add that team, or maybe some other team, or maybe even multiple teams in order to close their gap. So let's do an example. Next slide, please. So let's say there are women at Big State University who want to start a Frosh women's basketball team. And let's just say, for the purposes of this example, that the viable team size for Frosh women's basketball is 15 players. So step 1, let's count the number of athletics participation opportunities for women and men. So in this example, let's say BSU offers 1,000 athletics opportunities and 500 of them are for women, so that's 50%. So to find the participation gap, we have to look at enrollment. Let's say BSU has 50,000 students and 26,000 of them are women. So that means the enrollment percentage for women is 52%, but the athletics opportunities percentage is only 50%. So the participation gap is the 52 minus the 50, which is 2%. So here's what it gets a little bit trickier. We want to convert that participation gap percentage into the number of women's spots that must be added. So you might think, oh, well, 2% times 1,000, that's 20. We have to add 20 spots. That's actually not the case. You have to add 42 spots. And here's why. If you add 42 spots for women, then women would have 500 plus 42 is 542 opportunities. And the total number will be 1,000 plus 42, which is 1,042. And when you divide those numbers, you get 52%. So it's not, it's a little tricky. It's not necessarily intuitive, but 42 is a number that you have to add. So finally, the last step, let's compare 42 with the sizes of viable teams. Well, we said earlier that the viable team size for women's Frosh basketball is 15. 42 is bigger than 15 by a lot. So if there are women at BSU who want to start a Frosh women's basketball team, then BSU is in violation of Title IX unless it adds that team, and also probably needs to add a few other teams to close that gap, because you would still have 27 missing spots even after you add the 15. So that's an example. Next slide, please. Okay, so we've talked about substantial proportionality. Now we want to talk about prong 2 of the 3-part test. So let's say you can't show that the school meets the substantial proportionality test. Well, the school might argue, well, we can't meet prong 1, but we can meet prong 2. So here's how you see if they're meeting prong 2. Prong 2 means that a school has expanded athletics opportunities for girls in the past and is still continuing to do so today. Now, note here that Title IX was passed in 1972, so it's been almost 50 years. And it made sense in 1972 to let schools show that they were expanding their athletic program without necessarily, meeting prong 1, substantial proportionality. But it's been almost 50 years now, and it's really very unlikely that a school has been expanding this whole time in the past and is still continuing to do so and hasn't met substantial proportionality. So here are some ways that a school could. Let's say they have a record of adding girls' teams or adding girls to existing girls' teams, and they have a current plan of still doing that today. And they're doing this in response to girls' developing interests and abilities. That could work. It might even be possible that they cut a girls' team because there was not enough interest or ability, but they added many other girls' teams. And so they're still having a history and a current practice of expanding the girls' program. Here are some ways that a school would not meet prong 2. They added girls' opportunities early on, let's say like in 1975, and they have stopped doing it since. Or maybe they only cut girls' teams, but they have not added any. Or maybe girls have been sending in requests. They want to add more teams, but the school has just not responded. Or maybe they keep saying, we are going to increase girls' opportunities in the future, but they've only promised it and they have not actually done so. And finally, this last one's very important. Some schools think, well, why don't we just cut the boys' teams or cap the boys' teams? Or maybe we'll cut both boys and girls teams, but we'll cut boys teams more than we cut the girls teams. That should work. That is not going to meet prong 2, because the key part of prong 2 is expansion of the underrepresented genders program. So if you're not expanding girls teams and all you're doing is cutting, even if you're cutting boys more than you're cutting girls, that's not going to cut it. Next slide, please. The third prong 3, is accommodation. So this is where if a school fails to meet both prong 1 and prong 2, then they can still comply with Title IX if they say, well, look, we are offering all sports that a sufficient number of girls want to play and for which there is available competition. So here's how you would analyze that. Is the school using some method or some combination of methods to assess interest? For example, surveys, interviewing with coaches, sending out questionnaires to athletes to see what other sports they would like to play. Are there requests from girls to add new teams or to upgrade an intramural or a club team into a competitive interscholastic team? Is there even a process for students to request new teams or new opportunities? And it's very important here, a school cannot just say, well, we sent out a survey, so we meet prong 3. That's not enough. And they also can't say, well, we sent out a survey and nobody responded. That's how we know we've met prong 3. Neither of those will work. They have to show that they actually have assessed interest. And then, is there available competition? For example, are there other schools in the school's league or in the school's geographical area that offer the team in the same sport? And if that's the case, if you have both interest and competition, then the school must show that it is offering sports in all of these areas where there is interest and competition. So very important, if a school cuts a girls' team that had a full roster, then it clearly does not meet prong 3 because there was clearly interest to play that sport and they were already competing with their full roster. So if they cut that team, then they have failed to meet prong 3. So we've talked about all 3 prongs. Now we're going to talk about, next slide, please. We're going to talk about the second requirement under Title IX, right? Prong 3 only applies to equal opportunities to play. Excuse me, the 3-prong test applies to equal opportunities to play. Now we're going to talk about another requirement, which is equal benefits and services. So here, what this means is that the school is treating girls and boys or women and men fairly and making sure that they're receiving equal benefits and services from their school overall. Sarah alluded to this earlier. This is a total program test. And so it's very possible that maybe, men are treated better than women in one sport, but maybe women are treated better than men in another sport. And what you want to do is look at the program overall. However, in real life, if you see a gender disparity in one sport, that is usually an indication that there is a program-wide Title IX violation. Another thing to remember here is that schools do not have to spend equal amounts of money or provide identical benefits and services. What is important is that one group is not receiving second-class treatment. So it is okay if a school spends more money on men's uniforms than women's uniforms, if that's just because men's uniforms cost more. But what is not okay is if a school is buying top-of-the-line uniforms for men and bargain basement uniforms for women. And Sarah already talked about this earlier, there is no booster club exception. So let's say a school has accepted booster club money for a pitching machine for the boys baseball team. Then it has to do one of these things. It could give both the boys and girls teams equal time with the machine. It might have to buy a similar machine for the girls softball team with school funds. Or it might have to, if it doesn't have enough school funds and there is not a softball booster club, then you have to just go solicit other funding and make sure that girls are getting that same treatment so that they're not receiving second-class treatment. Next slide, please. So these categories are in the laundry list that Sarah referred to earlier. I'm not going to go over all of these, but you can, read them. And what's important here is that this is a very comprehensive list and it goes through every single type of experience, as Sarah said, in a way that an athlete experiences their athletic program. A lot of these, are probably pretty intuitive, but one thing that I wanted to point out is about coaches. It's not only about the quantity and quality of coaching, but it's also about the way that they're paid. It's about their non-coaching duties that are given to coaches. So is the boys baseball coach given very light duties outside of coaching, while the girls softball coach is also advising multiple other extracurricular activities and things like that. Next slide, please. Here are other categories in the laundry list: facility, publicity, etc. And at the bottom, you see there are some categories that mostly apply to college athletes, and that includes recruitment staff, recruitment trips, budgets, etc., access to tutoring and what athletes' tutors are getting paid, athletes' housing and dining services, and any additional monies that are being given to athletes through the school. Next slide, please. And the third requirement under Title IX for athletics is a fair share of scholarship dollars. So this means that the percentage of total athletic scholarship dollars awarded to men and women in sports must be within 1% of their participation rates or one scholarship, whichever is greater. And the key thing here is to focus on the total scholarship dollars, not on the number of scholarships or on individual dollar amounts. We're looking at dollars overall. So for example, if women are 50% of athletes at a school, then women should receive 49 to 51% of total athletic scholarship dollars. The only exception is a school can have a gap that is larger than 1% or one scholarship if the school can show why this larger gap is not discriminatory. So for example, let's say a school gives more out-of-state scholarships to men. Now, we all know that typically out-of-state scholarships will cost more than in-state scholarships because of the way tuition works. And so in this case, the dollar gap could be larger for men than for women. But the school would then have to show that it is not discriminating based on sex when it is recruiting out-of-state athletes. And therefore, it is not discriminated based on sex when awarding more out-of-state scholarship dollars to men than to women. So that is the only way that a school can award a gap that is larger than 1% or one scholarship. Next slide, please. Okay, and finally, before I wrap up, I wanted to address a couple of myths that are very common that you might hear from a school if you're representing a student in a Title IX athletics complaint. A school might say, well, Title IX requires quotas and it's unfair. That's not true. Title IX does not require quotas. Quotas actually don't even make any sense because men and women are not competing for the same spots. They're competing for spots on different teams altogether, and it's entirely up to schools to offer more spots for a gender that is underrepresented. And courts actually agree with this. They have specifically named that the idea of a quota is a red herring. Another important thing to keep in mind, and Sarah alluded to this earlier, Title IX does not actually require or even encourage schools to cut men's sports. Schools choose to cut smaller men's teams instead of reducing their very bloated football budget or their men's basketball budget. But that is a choice that those schools make. And so if they're choosing to cut other men's teams instead of reducing or controlling their football or men's basketball budget, that is not Title IX's fault. In fact, schools overwhelmingly have been able to add girls' teams and women's teams without cutting men's or boys' teams. And we have a note here that just says a school cannot comply with prong 2, which is about expansion, or prong 3, which is about accommodation, by only cutting a boys or men's team. So even if they choose to do that, they would not be complying with prong 2 or prong 3 by doing that. Another myth is that men's basketball and football programs bring in a lot of money, and that's why their budgets are so big. It's because they bring in so much money, and that's actually not even true. Most football and men's basketball programs spend much more money than they actually bring in, and the typical losing programs have annual deficits of $4.2 million for football and $1.3 million for men's basketball, respectively. So these are not programs that are actually bringing in money. And there's another statistic I want to share with you all. In football and men's basketball, more than 40% of the typical Division I teams for football, and 97% of the typical Division I FCS teams for basketball don't actually make enough money to pay for themselves. That's 40% and 97% for football and basketball. So the idea that you can spend more money on these programs because they're bringing in more money is just really not true. And finally, Title IX does not require equal spending on girls and boys sports. We talked about this already earlier. It's about not being given second-class treatment. And I think those are the ends of my slides. So I'm going to pass it over to Kim Turner to talk about OCR complaints and other Title IX matters.
Thank you. Appreciate that. Hi, everyone. Hopefully you can see me and hear me. Let me know if not. So yeah, if you could advance the slide, please. We'll be talking next, and thank you for the past slides. Such a helpful foundation. I also just want to flag how excited I am about this webinar today. Part of the reason we're doing this today, and thank you to National Women's Law Center and the network, is because there's just not enough training on Title IX athletics issues out there, and we need more. And there are experts, not many, unfortunately, but a lot of great experts in little pockets around the country who could be helpful. So including some of which I see on this webinar. So I look forward to this being recorded and shared with as many folks as you know out there. I'll also flag that this is not just for lawyers. This obviously is geared toward lawyers and non-lawyers, because we want everybody in the game of Title IX enforcement and discussion and awareness and compliance. I'll just quickly add to my background. So I'm Kim Turner with Coaching Core, Director of the Gender Equity Initiative, and I have been working over the last 9 years with Fair Play for Girls in Sports, a project of legal aid at work. And I know there are some Fair Play folks on the call, on the webinar now, who are terrific Title IX experts, as well as co-counsel from some of our cases over the last several years. So I hope everyone can reach out to those experts. At the end, we can name some of those folks, like Elizabeth Kristen at Fair Play, who's done the K-12 cases with me over the last many years. And I look forward to more discussion about all the great work that these experts and advocates have done and how we can get that expertise to others. So let's talk a little bit now about OCR complaints and other pre-litigation strategies. And I will build on some of those prior comments and slides as I go along. If you could please advance the slide. So, let me also add that I'm an athlete. I grew up playing all the sports, and I'm a mom now of 2 children, a daughter and son, and I am a grateful beneficiary of Title IX. In fact, I went to Brown University and played volleyball there because of a Title IX lawsuit brought against Brown University to save the women's volleyball program and equalize opportunities, treatment, and benefits there. And my co-panelist, Arthur Bryant, worked on the Brown case. So it's very special for me to be on this panel with Arthur and amongst company that helped preserve and equalize my college sport opportunity. So let's talk a little bit about Title IX athletic equity enforcement options. So there's multiple routes to spur enforcement of Title IX in athletics. And I really like this slide because people don't necessarily realize that there are many avenues to spur compliance. So here are a couple, depending on where you are. So this applies to anyone, any state across the United States. The Department of Education Office for Civil Rights, the federal agency, takes Title IX athletics complaints and other types of Title IX complaints. You can file electronically or via mail, I think even over the phone. It's a pretty easy process, but there are obviously ways to do it more effectively, and it helps to have an attorney involved, but it's not necessary. So if folks want models of OCR complaints, they can contact me or others in this group. I will say that the drawback and the challenge of the OCR complaint is that it often takes a long time. In my experience, bringing OCR complaints with a couple of families, it's taken 3 or 4 years to resolve the issue. And oftentimes, say in the K-12 context, a girl has graduated from middle or high school before the OCR complaint gets resolved. The benefit is that the future girls in that school will have more equal opportunities, treatment, and benefits. Another avenue is the State Department of Education. I have worked a little bit with our California State Department of Education. I'm located in California, and they have actually done a pretty good job of handling complaints, and certain states are particularly well equipped. Certain ones could do better, I'm sure, but working with your State Department of Education is one way, and there's often a state counterpart to Title IX in state law, as well as the State Athletic Association, the governing body. So Many states have a high school state athletics association. Sometimes they cover middle school sports and other activities. But in California, for example, we have the California Interscholastic Federation, the CIF, and they have Title IX-like policies and procedures for folks, athletes and families, coaches, schools that encounter gender discrimination issues in athletics. And sometimes they can be very effective in handling a complaint or in resolving an issue before it needs to go to court or to OCR. And then the demand letter is another route. And in my fair play time litigating and working on cases, oftentimes we would simply send a demand letter to the district about a school's gender inequity and athletics issues, and the district would resolve it with us from there without needing to go to court. So sometimes that direct communication can be very effective in getting a settlement or resolution. And then finally in this list is a lawsuit. So one can file a Title IX athletics lawsuit. We, in my fair play experience, filed in federal court, and there was no exhaustion requirements. People don't realize, and this is kind of a practice pointer for lawyers out there, compared to Title VII and employment actions, for example, where you'd have to go, say, through the EEOC, Title IX doesn't require exhaustion. And that is a benefit in these lawsuits, that there's less bureaucracy and less sort of red tape to going to court. Okay, so next slide, please. Let me just add too that all of these points I'm making, we could talk hours about any single one of these bullet points. So I look forward to questions over email. Our contact information was mentioned in the beginning of the presentation, and we can put it in the Q&A at the end. But we look forward to chatting with people whenever about these issues. And hopefully, with this recording, you could review it and talk more with the experts about these issues. So a couple of points about the equity enforcement options under Title IX athletics. These are some practice and approach pointers that I've learned over my near decade of experience in terms of non-litigation or pre-litigation options. Now, I focused on K-12, and we were focused on elementary, middle, and high school girls. And we were working with those girls and their families who have a range of goals and a range of options. So what I learned over my years, and frankly, as a parent too, is that families have different needs, different desires, different levels of comfort. So some might feel good about an Office for Civil Rights complaint because it is easier for them to stay out of the limelight. They may, they don't have to use their name publicly. Sometimes an OCR complaint will draw less press attention or no press attention. So OCR complaints work for some families, whereas other families might say, look, we really want a lot of press attention on this issue. To Sarah's earlier slides on the South Carolina softball baseball issue, that dad was taking a reporter around to those fields. I think sometimes that's absolutely necessary for the community, the city, the state, the nation to see these issues. So press and publicity can be very helpful, and lawsuits often generate publicity. So you have to work with the family on, what level of publicity they would be comfortable with. Are their daughters comfortable being interviewed or deposed, in a court situation? So really want to go over that menu of options and approaches and find out what works for families and girls. And it's hard because we're dealing with minors in these K-12 cases. College cases are a little different, but in the K-12 cases, we're often dealing with minors. And it's a big decision for a family to endure a litigation. It's wonderful and courageous when they do, but it's not easy necessarily. So we want to go over those things before, and all those options I mentioned on the last slide are available to families. You also want to review and think about timelines and different approaches. They do vary. As I mentioned, an OCR complaint can take a couple of years to be resolved. I hope that goes quicker, and maybe with funding for OCR and the new administration, complaints can be resolved faster. But OCR takes quite a while, whereas sometimes a pre-litigation demand letter to a school district can resolve a matter within a year or less. We've had some cases where a letter to a district highlighting the issues can resolve things quite quickly. And then, of course, litigation is a bit unpredictable, can take several years, can sometimes take less time depending on the dynamics of the case. But think about timeline. And again, let's point out that, these are minors. They only have one shot at high school sports. Of course, we want these timelines to be reduced so that girls and women can experience equity in their lifetime, in their school career, and not, years down the road. So try and think about timelines that are efficient. The other thing is considering the importance of instilling lasting and comprehensive athletic equity across an entire athletic program. And as Elizabeth and Sarah spoke about, this is a total program analysis. We, of course, will have situations where a girls softball team or a girls lacrosse team will come to an attorney or an advocate and say, hey, we've got a problem. And of course, we want to focus on those problems when they're acute. But as Elizabeth alluded to, and others, if one girls team has a problem with inequity, like they're lacking access to locker rooms, or their schedules are worse than the boys teams, or their coach is not being supported with a stipend, those issues are probably rampant throughout the athletic program and probably affecting other girls and women's teams. So do, as an advocate or an attorney in the space, think about how to talk with all the girls across the program on their different teams and find out what's going on systemically, so that any intervention, in fact, equalizes the entire athletic program for girls and women, rather than just for one team. And then note privacy concerns. I did mention minors are involved in these K-12 cases that I've done. Of course, filing a litigation with their names publicly shared, is a big decision for a family. Some families are up for it and it's okay for them. Some do not. I would prefer a DOE approach or anonymity in some respect. So happy to talk offline with folks about those different approaches and privacy concerns when minors are involved. Okay, next slide, please. Okay, so a couple tidbits about athletics litigation that I've worked on. If you can advance the slide, please. And of course, again, I could talk all day about all of this, but these are some reminders. And maybe there's somebody on the call who's the parent that's just trying to learn about Title IX at their kid's high school or middle school, or an advocate that's not an attorney. I really think one of the keys is to make this accessible for everybody and not just kind of legalese that feels intimidating. So here are some nuts and bolts of, say, a K-12 Title IX case, a litigation. So as mentioned, and we can't say it enough, total program analysis is key. You're going to look at all the girls' sports and the boys' sports, or women's and men's, in a college context, and put them on the scale and see how are all these teams treated. And in my experience in these cases over nearly a decade, I never saw an athletic program where girls were treated better than the boys. So we really have a crisis nationally in terms of inequity in public school athletics, because those are programs subject to Title IX. And so where Title IX applies, we really do need to be enforcing it more, because almost always girls are getting the short end of the stick. And these are public resources, and this is educational. People forget that sports are educational for youth. So we should be making sure, as they would have equity with their textbooks or with their classes, they need equity on the field and in the gym. Another point is, people don't realize very few cases have been litigated in terms of Title IX athletics compared to other civil rights areas of law, other fields of law in general. Now, there are pros and cons to that. The good news is that one that's thinking about practicing Title IX athletics law can learn it quite quickly. There are not that many cases to review. Maybe a 3-inch binder could accommodate all of the cases if you printed them all out on Westlaw or Nexus. So the good news is you can learn quickly and understand the terrain pretty quickly. But the con of it is that there may not be a case on point with the issue you're facing in a particular city or situation. So, oftentimes we have to thread together what's out there, and of course, look at the regs, look at the precedents, and the spirit of Title IX, and help further the law. We all need to be enforcing it that much more and developing the case law. Let's also point out that it's about education. So Title IX, and this webinar is part of that, but you are often, as a Title IX advocate or attorney, or even a family member that shows up to a board meeting, you're educating people about Title IX athletics. And I was an athlete growing up. I played everything. As I mentioned, I played in college, but frankly, as a high school or college athlete, if you quiz me on Title IX basics and the 3-part test, I would not have known the basics growing up. And so one of my goals in life is to talk to anybody who will listen about the basics of Title IX athletics equity, and how can we make sure that this is accessible and easy to understand. So in terms of the cases and compliance and enforcement, that means if you're, say, bringing a case or sending a demand letter, you're educating the school and district leadership all the while. You're educating your own clients to know their rights. You're educating counsel for the district, outside counsel or inside counsel, because they probably haven't gotten a lot of training on this. You're educating the judges. So you have to, when you're writing briefs, you want to have a 101 on Title IX, a 101 on the 3-part test. Do not assume that judges or a counsel across the table from you understands the law or has had good training. We need more law school courses on this. We need more undergrad courses on this. We need more graduate degree courses on this. So please continue to educate. And then the community. So if you do training, of course, school board meetings, city hall meetings, do educate as much as you can. And then the press, if you're an attorney that's talking to the press, you often have to go back to the basics. Well, what is the 3-part test? How do treatment and benefits work? I'll just remind folks that retaliation is not permitted under Title IX. So there's a separate cause of action if there's been retaliation against a girl, a family, a coach, for pointing out gender inequity in the athletics program. And people don't always know that retaliation is its own cause of action and is completely prohibited under Title IX. I'll also say you want to review the cases and materials. So if you're practicing this area of law, and of course, this isn't legal advice, this training is general information, but before you embark on any type of Title IX intervention, look at National Women's Law Center's Check It Out guide. It's terrific. I can try and put that in the chat, or maybe someone else can. And then OCR Dear Colleague letters have a lot of great guidance, but frankly are very dense. So if you ever want to talk about Dear Colleague letters with me or any folks on this call, on this webinar, we'd be happy to chat through it, because I think the Dear Colleagues can be somewhat inaccessible to the layperson. Thanks, Elizabeth, for putting the Check It Out guide in there. You want to also look at the policy interpretation, which is a great basic set of precepts that we use in Title IX practice, and lays it all out. And then the Code of Federal Regulations has a lot of detail, because as Sarah pointed out, the law itself is very short. It's just a few words, but it's with the regulations, the Dear Colleague letters, and nearly 50 years now of interpretation that we've learned how best to apply Title IX. Okay, so next slide, please. And then I will wrap it up and pass it on to Arthur. So some key cases, if you're wanting to learn how does a K-12 athletics litigation work, Ollie v. Sweetwater is a case that I was lucky to work on from 2012 to 2021. And Elizabeth Kristen at Fair Play, Legal Aid at Work's Fair Play for Girls in Sports Project brought this case with California Women's Law Center and Manat, Phelps, and Phillips. And in that case, it's kind of a classic example of all the issues we've talked about. Softball treated much worse than baseball. Other girls' teams treated much worse than other boys' teams in terms of facilities, equipment, supplies, scheduling. And there was retaliation in that case when the girls and families spoke up about inequity at the school, Castle Park High School in Southern California and San Diego area. There was retaliation. And in that case, we prevailed at every turn in terms of a summary judgment phase, in terms of class certification, in terms of a trial. They went all the way to trial. And then on appeal before the Ninth Circuit, we prevailed. And so Castle Park High School, part of the Sweetwater District, is being monitored until 2024. And folks can get all the copies of all the briefing from that case from me or others as needed, but definitely a kind of classic case that I think that gives a nice primer to people on how these cases could be brought if you're litigating. I'll also point out Communities for Equity versus Michigan High School State Athletic Association was mainly a scheduling and sports seasons case, very well done. Kristen Gallus was a leader in that case. I know National Women's Law Center has been instrumental in a lot of these cases too. So you can check that out on Lexis or Westlaw. And then quickly to wrap up some takeaways. So there's no intent requirement or no subjective knowledge requirement in these cases compared to complex Title VII cases or even other types of Title IX sexual assault and harassment cases, where you deal with these issues. Here, it's about policies. It's like if they give the girls less, if they give the boys more, if the facilities are worse for girls versus boys, the naked eye can see it. It's not subjective. It's not whether you cared for the girls or you didn't. You just gave them fewer resources and their teams are worse off. So luckily, it's kind of it's not a strict liability statute, but it's almost there. It's kind of very basic, objective facts involved. We typically seek injunctive and declaratory relief. There's typically no monetary damages in a K-12 athletics litigation. And then I just want to emphasize the power of pictures and video to the extent that, of course, you can get photos and video, with the families might send you a picture of their daughter's softball game or their daughter's, basketball game where you can see that the girls are being treated worse. They have, worse facility or struggling to get that support that they deserve under Title IX. We find that photos and video appropriately taken and site visits are very powerful. And judges say, wow, like anyone could tell that this is unequal. Of course, there's more to it, but sometimes it's a very kind of simple analysis. And then monitoring is key. Make sure that any settlement or intervention or resolution you have ensures that for years to come, the girls' athletic program will be treated equally and that they won't just kind of superficially fix things up for 1 week and then go back to their old ways. So make sure that there's lasting change. All right, so I could speak more about all of this at some point. Happy to answer questions later. And thank you for your attention. I'm going to pass it to Arthur.
Hi, everybody. It's great to be involved in this. I want to start by just saying I am absolutely thrilled that so many people are here, because one thing we need more than anything is more people enforcing Title IX. I want to talk about the big picture a second before we move into the details. Next slide, please. And I should say my background is, so I'm Arthur Bryant. I am now with Bailey Glasser. I created their Oakland office in California. Great law firm. I was the lead counsel for trial in the very first Title IX case against a school for discriminating against its women athletes. That was Temple University in Philadelphia in the 1980s. And then after that, school after school would eliminate a team. I would get a call. We would threaten to sue them. They'd agree to put it back. And no litigation was really necessary, with a couple of small exceptions, until the 1990s, when Brown University decided it wanted to fight full-time. And we won every step of the way and made new law up and down the courts. And I was thrilled to learn that Kim Turner was one of the class members we helped. And I know that Lynette Leibiger, who was our lead counsel in the case, is in the group today. So I'm thrilled to see that. And then I spent the rest of my time, I was with public justice, and built that from me and the receptionist to me and 42 other staff, 23 lawyers, doing cutting edge impact nationwide litigation. And wasn't that involved in Title IX litigation because I didn't need to. Somehow the slides are messed up. If somebody can get back to college litigation, I'd appreciate it. But I'm concerned that anybody here would have the false impression that Title IX litigation is really hard and really complicated, and the analysis is very difficult. So I want to be very clear about this. Despite everything you just saw, Title IX analysis and litigation is not very difficult at all. This is a fundamental issue of fairness. If you have separate athletic teams for athletic programs for males and females, those separate programs have to offer equal opportunities, equal athletic financial aid, and equal treatment to the males and the females. That's it. It's separate and equal. Analysis is very clear. The problem is that most schools in the country are not in compliance. So we're back to recent developments, key issues, and what's ahead. So now I want to say is, when I started the West Coast office in Bailey Glasser in January of 2020, what I knew is we were going to do impact litigation that hopefully made the firm money, but I had no idea what kind of litigation we were going to do. And I am somewhat stunned to see that basically I'm doing 90% of my time on Title IX litigation, and it started when in June 2020, Lynette Leibiger in the group called me and said, "You're never going to believe this, Arthur. Brown just violated our 22-year-old settlement agreement. We have to go back and hold them accountable." So we did. And while that was going on, school after school after school started to eliminate teams. Ended up forming at Bailey Glasser an entire litigation team to work on Title IX cases. And that includes some of the people in the audience, including Elliot McGraw and Jade Smith-Williams. But here's the big picture, recent developments first. The fact that there is nationwide violation and enforcement by litigation primarily, that's not new. That's continuing for some time. The fundamental problem with Title IX is not that the law is not clear. It is that there's not adequate enforcement. And that's why I'm so glad so many of you are here. What has happened in the last year and a half is that COVID-19 and financial pressures in particular are prompting cutbacks of men's and women's teams. But since what's happening is most schools are currently in violation by discriminating against women, it's when they eliminate a woman's team, they are creating lawsuits, particularly by upsetting women who have lawsuits and have no reason to sort of look into it and bring them until their teams are eliminated. So the problem is not just that COVID-19 and financial pressures are prompting cutbacks, but the problem for schools is that you cannot discriminate against people because of COVID-19. You cannot discriminate against people to make or lose money. They are not valid defenses. And the schools are making the mistake of eliminating teams. So they're already in violation, usually because they're depriving women of equal treatment, often because they're depriving them of equal athletic financial aid and opportunities. And then they eliminate a women's team who has a slam dunk case to get the team reinstated. So the litigation strategy and approach we've been using is we go to the school, we write a letter, we go to the school, we say, here are the numbers, here's why you're in clear violation. We suggest you meet with us. We meet with them and we say, here's your choice. Either you put the team back and agree to do a gender equity stand and agree to get in compliance, do a gender equity gender equity review and get fully in compliance with Title IX in all aspects of your intercollegiate athletic program in the next couple of years, or we're going to sue and the court's going to make you do it because it's the law. You really have no choice about it. And in the last year and a half, next slide, please, as a result of that approach, recent developments, here's what's happening. Brown University, we settled with them after they violated the original 1998 settlement. We enforced the settlement and we reached an agreement that actually enhanced the protection for women at Brown. And on top of that, what we realized is that the settlement from 1998 actually didn't protect women as strongly as the current law does. So we let them get out of the settlement in 4 years from now. But so there we got them to put 2 women's teams back right away and maintain the rest that were already there. The approach I just mentioned has already worked school after school. Schools that agreed to reinstate teams, develop gender equity plans, and get into compliance without any litigation. William and Mary, East Carolina University, UNC Pembroke, Dartmouth College, Clemson University, which was actually a school that eliminated men's teams in violation of Title IX, University of St. Thomas, LaSalle University, and we're actually in negotiations with Dickinson College right now as to whether they will do that. In the cases that went to litigation, quick reinstatements of the women's teams were won in Iowa and Yukon. Quick reinstatements, preliminary injunctions were lost in Michigan State University and Fresno State, but those battles are continuing and the Office for Civil Rights is already supporting women against Michigan State in the Court of Appeals. Next slide. Now, here are the key issues in terms of the law and enforcement. First, equal participation opportunities. What the defendants have come up, their defense counsel has come up with a couple of new arguments over how you measure substantial proportionality under part 1 of the 3-part test. The law is, as was correctly stated, like by Sarah from the very start, is if the gap is not large enough, the participation gap is not large enough to support a viable team, then you're in compliance. But if it is large enough to support a viable team, then you're in violation. The defendants are making 2 new arguments. One is if there's more than a 2% gap between enrollment and participation numbers, that's when you're in compliance. And if it's less than that, and you're in violation, pardon me. And if it's less than 2%, you're in compliance. That is not true. Or if the participation gap is larger than the average team size, you're in violation, which isn't true and makes no sense. What it means is if a school had 4 teams of 50 people each, it could cut all the rest of the teams in the program. And it wouldn't matter because then the average team size would be larger than the gap left by getting rid of everybody else. And the Office for Civil Rights just wrote an amicus brief forcefully rejecting these arguments. It's in the 6th Circuit now. The other arguments that are going on is, in terms of the issues, are should athletes be counted more than once, and if so, when? So one of the ways some schools are sort of getting around the intent of Title IX is the Office for Civil Rights has said when you have indoor track and outdoor track and cross country, people who are on all 3 of those teams, even though they're basically doing the same thing or close to it, get to be counted as athletes 3 times for Title IX participation purposes. So what that means is if a school really wants to, it could have only a women's indoor track and outdoor track and cross country team. And then the women who run cross country, for example, who are on all 3, could get counted 3 times. Whereas if they don't have, the school does not have the male team, or any of them, those men, all the rest of the men in the program get counted once. It's a way of fixing the numbers. The other thing that's going on is that while men are double counted or women are double counted for track, field, and cross country, or triple counted, when it goes to athletic financial aid analysis, everybody's counted only once. So the participation number actually is different depending on whether you're athletic financial aid or you're looking at opportunities to play sports, which is kind of crazy, but that's one of the key issues up is that change. And the larger key issue for all of us is how do we get schools to provide equal athletic financial aid? How do we get schools to provide equal treatment and benefits? Next slide, please. Which gets us to what's ahead. Next year is the 50th anniversary of Title IX. It is an opportunity first to get an enormous amount of public education around this. And a key part of the public education is not just educating the general public, but also women and parents, girls and their parents, because they're the ones who have to be the plaintiffs in litigation to enforce it. They're the ones who have to bring to your and our attention the violations so we can fight for them. And so I view the opportunity, the 50th anniversary, as something presenting all of us with a chance to make a big difference here. But when you look backwards and you think, this has been the law for 50 years, how is it that still a basic fundamental rule, women are entitled to equal opportunities, financial aid, and treatment, the schools still aren't in compliance with? So we also have to use this to really ramp up pressure on the schools through litigation and otherwise to get into compliance. Another big question is, will the government finally take affirmative enforcement action in the courts to enforce Title IX? It's been 49 years. Not once has the federal government brought an action in court to hold the school accountable for violating Title IX in athletics. It's about time if they did it once with some major program, say University of Alabama, Texas, Southern California, any big school, Notre Dame. It would make an enormous difference, not just for that school, but every school in the country. Because the problem, like I said, is not a lack of clarity in the law, it's a lack of enforcement. I think another thing that's what's ahead, partly because of the 50th anniversary, is increased awareness and enforcement, including against the NCAA through private litigation. And in there, I will tell you, we are looking for all of those kinds of cases. I've got a team at Bailey Glasser. Anybody finds cases, including against the NCAA, for straight out Title IX violations, call us. We are dedicated to making a difference here. I expect that the key issues that I just flagged a minute ago in litigation will be addressed in what's ahead. And I also expect increased resistance by the schools. And actually, some of that is going to stem from what was mentioned a couple of minutes ago. I think it was Sarah mentioned NIL, and it wasn't clear how Title IX applied. And I want to be clear how we see it. If a school is not involved at all in providing the name, image, and likeness benefits, if a private company cuts a deal with this and says, I'm going to pay the football players all $500 a month, and the school is not all involved, I don't think it's a Title IX violation. If they give it just to the football players and to no women's, it's still not a Title IX violation. But if the school is involved in any way, that's a whole different ballgame. And I believe in most of these situations, the school is directly involved, including by letting its trademark be used, et cetera. So we expect a wide range of NIL-related Title IX litigation. And again, if you see outrageous examples, call us, because I think the developments of both NIL and the antitrust enforcement against the NCAA and the schools is going to launch increased resistance. The schools, the NCAA's lawyer before the United States Supreme Court said, if you want us to give more money to these athletes, then we're not going to have the money to comply with Title IX. So you can see the push is going to be, and I'm already hearing it from athletic directors who view their job as making money and winning football and basketball games, that, oh, if you want us to, provide more money for the athletes, then you can't insist that we provide money for women, because what's paying for the women is the men. It's not true, but that's what they said. So I expect we're going to have increased resistance, but also we will need an increased willingness to fight and a need to fight. And so I hope all of you will join me and everybody else on this panel in making sure we do fight and making the 50th anniversary a time where we really can all do it, make a huge difference. Thank you.
Thank you so much, Arthur, and to Kim and Sarah as well. We now have about 15 minutes left for questions. So if folks have any, please feel free to drop them in the chat or in the Q&A box. I'm just going to start us off by asking our panelists here today, it's been almost 50 years since Title IX was passed. What do you think needs to be done to get schools to comply with Title IX in athletics?
I'm happy to jump in on that, Elizabeth. I have lots of thoughts about it. I will say awareness is maybe one of the biggest things ever, because I think people see girls playing in their neighborhoods at school or on TV in a pro or college sport and think we're done. But when we dig down and notice that there's a 1 million girl gap in high school, for example, so boys are getting 1 million more opportunities than girls to play high school sports across the country, and girls want to play in much greater numbers, but they're not getting the seats at the athletics table that is set by the schools, or being asked, what do you want to play if we grow girls programs? So we need to dig into the numbers and build awareness that girls and women deserve more, they deserve equal, and we need to be, gumshoes in our own communities. So anyone on this call, check out your local high school, check out your local community college subject to Title IX, check out your alma mater, your university or college where you went. You're going to find inequity in athletics for girls and women. And yet it's not rocket science to fix the issues. As Arthur pointed out, there's some real simplicity to this. And all of our groups have amazing tools to help you analyze the problems and then request change. We could send sample draft demand letters, OCR complaint drafts, sample litigation pleadings, discovery requests. We have a whole arsenal of tools to share. So I think raising awareness and then giving tools to people to deal with the issues and not giving up, saying, hey, what is ahead in the next 50 years? It's ending gender discrimination in athletics, period. Not waiting for any more excuses, because girls and women deserve educational equity, which includes athletic equity. So those are a couple thoughts.
I would add publicity makes a huge difference to the schools. I mean, the NCAA, which insists it's not subject to Title IX, you saw what happened when just that little video went out comparing the weight rooms for the women at the Final Four versus the men at the Final Four. And it embarrassed the hell out of them. They actually did take action. Whether it's enough, we'll see. But every school in the country is subject to that kind of embarrassment if they're not in compliance. So I think a big part of it is actually exposing unequal treatment, because people don't like it when they learn about it. Second, like I said, I think enforcement is what's most needed in terms of making the schools do it. And the third, I would say, is leadership. And that is, I've met with coaches and I said, so why is this a problem? Why, after 49 years, are your schools not in compliance? And they say, because there's no accountability. The board doesn't say to the athletic director. The president doesn't say to the athletic director, this is important to us. What the athletic director thinks is important is wins and money. And nobody is saying, okay, fine, we would like you to have wins, and if you can, we'd like to have money, but it's subject to first complying with federal law that prohibits discrimination. And that's got to come from the school's leadership, the boards and the presidents. And I'm not sure how, but that's how we need to sort of spur them to do that. Because if they take the lead, it'll make all the difference.
Thanks so much, Kim and Arthur. Sarah, feel free to jump in if you have thoughts to add. I also wanted to just note that Elizabeth Kristen asked a question in the chat. Any reason to think that PPP loans to private schools would not trigger Title IX coverage there? And actually, the SBA actually put out a memo or some sort of guidance document last year explaining that when any entity receives federal funding through the Paycheck Protection Program, they are subject to federal civil rights laws. And so the way that this works is the entity is subject to Title IX and to any other type of law contingent on federal funding until they repay the loan or the loan is forgiven.
Elizabeth, if there isn't another pending question, and I just wanted to add another point that we didn't get a chance to dive into, which is the benefits of sports for girls and women. So attorneys, advocates, the public on this webinar and who are interested, we have to also make the argument that there is a moral imperative and a health imperative to giving girls and women access to sports. And I think with the COVID pandemic, we know even more about, for example, diabetes being something making people vulnerable to COVID, for example. But a girl and a woman that gets to play sports is more likely to ward off diabetes. So we need to connect the dots to realize that a girl getting a chance to play middle school sports, high school sports, or vie for a college scholarship means she has lower rates of depression in her life, lower rates of breast cancer, higher rates of educational attainment. And what I love especially is higher wages as an adult. A girl who played high school sports has higher wages compared to her non-athlete counterparts. And she doesn't have to be an Olympian or even a varsity member of the team. She just needs that chance to get those life skills and the discipline and the teamwork and the goal orientation. So I'll put in the chat a really nice flyer of the benefits of sports for girls and women. But in our community conversations, we need to talk about how we're denying girls lifelong benefits by not letting them play. It's not just fun and games. So I will put that in the chat, and then I'll just point out Women's Sports Foundation has a million incredible reports on the benefits, and any of their reports would be great to share with a community group, a journalist, to the publicity point that Arthur makes, and with judges in briefs, because you have to make the point that it's not just the law, it's the right thing to do.
Thanks, Kim. Yeah, if I can just give a quick plug. Certainly it's, the health, academic, and social emotional outcomes that we see that are so critical for girls and women in sports and their experiences. The Women's Sports Foundation has a long, robust history of research on this topic, and many others as well. So I encourage you to check out our website, head over to what we do in research, and you can see all of our research reports are up there. One in particular that seems relevant to this group is from 2020 called Chasing Equity, the Triumphs, Challenges, and Opportunities for Girls and Women in Sports. And that's really a meta-analysis and a compilation of all of the research that's out there on this topic and looks at things from Title IX, education awareness and compliance, youth participation, media coverage, pay equity, gender bias, and leadership. And mental and physical health and safety. So really runs the gambit of all the things that we look at when we talk about gender equity in sports and the things affecting girls and women in sports. And that's a great report to check out, but we also have many other reports available as well.
Thanks, Sarah. And we have a new question. Thanks so much for sending in questions, everyone. This one is, today, the General Counsel of the National Labor Relations Board opined that certain college athletes should be classified as employees. If that is done, especially for football players at private schools, what are the implications, RE Title IX? And I did see a news alert during this webinar as well, saying the NLRB says student athletes can collectively bargain, that specifically student athletes at private colleges are protected under federal labor law, can collectively bargain. And yeah, I have not had a chance to read it thoroughly as we've been on this webinar, but if any of my panelists want to jump in to opine on what this means for Title IX implications.
Well, from my perspective, it's fascinating, and it also relates to the NIL stuff as well. But bottom line is, in Title IX analysis, for the most part, money doesn't matter. And that's what some schools just can't get through their heads, and what the general public can't get. This is a law about fairness. It's about right and wrong. It's about discrimination. So in the first in the Brown University case, Brown came in and said, well, we're spending more on football because football could bring in money. And unlike all the other schools, and I mean, all the other teams, and the judge issued a decision that said, look, you don't have to have an athletics program at all. If you offer no athletics program, you are complying with Title IX because women and men are getting the same thing, nothing. But it's equal. And that's the principle. It's a civil rights law. It's about equality. Whatever size program you offer, you have to treat men and women equally and give them equal opportunities and equal aid. And whether it makes money or loses money, whether it's the result of collective bargaining, which or some other thing, if you're not providing the equality that Title IX requires, you're in violation. So I think it's going to be fascinating to see how it fits together. But I don't think it's ultimately going to make any difference in terms of Title IX enforcement.
Thanks, Arthur. And Hannah Smith has a question as well. If the school offers a reasonable accommodation for the client, for example, allowing a girl to play on the men's team, is that adequate? I am thinking about / anticipating what schools will offer instead of adding an entire team for girls. Hannah is a law student.
Well, so Hannah, I can tell you that this has come up in a couple of different cases. And what the Title IX regulations say, at least in, if there is enough interest and ability to field a women's team in the sport, then they're supposed to field the women's team in the sport compared to the men's team. There's actually a case in the Ninth Circuit now where that's being litigated, where they actually were providing equal opportunities to participate, but by doing it, by not forming a women's team in a sport where there was interest and ability to do so when there was already a men's team. But there are, if there's not, then the question is, do they have to put the woman on the men's team? And there's an issue there. If it's a contact sport as opposed to a non-contact sport, that can get a little complicated. I want to try to summarize now. But basically, what Title IX generally looks at is women as the entire group of women versus the entire group of men. And they can't sort of get out of providing women equal opportunity by just giving one woman the treatment she wants at the sake of sacrificing the other women's rights.
Yeah, I'll just add to that, to Arthur's point, that, you know, a lot of times, at least in the K-12 context, like middle and high schools, we don't see close calls on accommodation in the sense that girls are getting a lot fewer opportunities than boys. And so if a girls team could be fielded and they have a large participation gap, say it's 49% girls in the school enrolled, but only 40% girls in the athletic program, that's a very large participation gap. They probably should be just adding that girls team. And so I would recommend to people to kind of try and bring the focus outward, away from these granular, tiny arguments, and look big picture to say, hey, why are girls missing out on 30, 40, 50, 100 opportunities at this high school or college, as is the case oftentimes, and try and focus there rather than on those more granular issues. I'm happy to talk participation gap at any point. One thing to add on that too is I know the algebra can seem a little daunting to some folks, but if you're explaining it to a judge or a reporter or to your own clients as they learn the law and their rights, it's really about proportionality. If a girl's share of the student body is about 50%, their girl's share of athletic roster slots should be 50%. You know, that's the gold standard. And then there's prong 2 and prong 3 if necessary. But let's focus on prong 1 and in college and high school and middle school, and break it down for people so that they understand that's just a basic fairness, as Arthur points. I mean, you don't need to be a lawyer to know that girls are getting less when you look at those rosters and teams.
Thanks so much, Arthur and Kim. It looks like that is all the questions that we have for now. We have about 2 minutes left, so if you have any other burning questions, please feel free to drop them. Otherwise, you know, I just want to say thank you again to all of you for attending today. A huge thank you to our panelists for providing so much important expertise and information. As you all know, this webinar is being recorded, and we will be sharing both the slides and the video recording afterwards. We'll be uploading it to the NWLC website. You'll all be notified of that if you register to attend this session. And again, you know, if you are not currently in the Legal Network for Gender Equity and you're a lawyer who wants to be added because you want to receive intakes from individuals across the country experiencing sex discrimination in education, whether that's in athletics, whether they're experiencing sexual harassment, anti-LGBTQ discrimination, gender disparities in discipline, pregnancy and parenting discrimination, whatever it is, you can choose exactly what types of discrimination you want to help assist with, and you can contact us at legalnetwork@nwlc.org, or again, reply to any email that you received from us about this webinar, and we can put you in touch and get you added to our legal network. And thank you again to everyone for the questions, for all the resources in the chat. We're at 4:30 now, so we're going to call it a day. Have a wonderful rest of your week, and thank you again.
Thank you. Take care.
Thank you,
Bye-bye.
everyone. Look forward to talking more. Take care.